Um, so I'm going to start. I'd like to welcome everybody to our monthly Rhode Island Commercial and Appraisal Board of Realtors virtual presentation. Tom Sweeney, Sweeney Real Estate and Appraisal. I am the president, the 2021 president of RICABOR. Would like to first start out by thanking our sponsor, Steve Kirby of Kirby Real Estate. I also would like to note that Patricia Flowers from IPX 1031 is on with us, one of our previous sponsors. And I would like also to reach out to Ocean State Business Development, Jim Tierney and Russ Gaston, who are also previous sponsors. The format here is, as has been in the past, we will have our presenters present. And then if you have any questions, please enter them in the chat. We've already gotten a couple in advance, but if you do as we go along, if our speakers bring up anything you want to address, please use the chat feature and we'll make sure that they get the questions. I'd like to now introduce our two speakers. First, we have Rick Mandile, principal and owner of SAGE Environmental. Rick has performed thousands of environmental assessments on all types of real estate on behalf of sellers, buyers, and lenders throughout New England and the East Coast. He holds an impressive 33 years of experience and success in Rhode Island and has captained the largest Rhode Island headquarter environmental firm, SAGE Environmental, which was awarded the silver medal in 2020 by the Environmental Business Journal for Small Environmental Business of the Year. He is a principal owner of SAGE, chairman of the Environmental Business Council, and a member of the Rhode Island Society of Environmental Business Professionals, the American Council of Engineering Companies, Rhode Island chapter, and subcommittee member of the Environmental Committee, the Licensed Site Professionals Association of Massachusetts, and the New Jersey Licensed Remediation Professional Association. He is joined today by Michael Donegan. Mike is a partner at the law firm of Orson and Brasini. Mike represents both public and private clients in all areas of environmental law, including federal, state, and local permitting associated with major commercial facilities, site remediation, brownfields, matters involving hazardous and solid waste management, land use planning and development, wetlands, and matters involving regulatory compliance, enforcement, and litigation. Mike has extensive experience in the permitting, development, and financing of energy products, including those before the Rhode Island Energy Facility Siting Board. Mike is the senior editor of the Rhode Island Environmental Law Handbook and has been rated by Martindale Hubbell as an AV preeminent attorney in the field of environmental law for the last 25 years. So with that, I give you Rick Mandile and Mike Donegan.
Thank you, Tom.
Thank you, Tom. Corey, if you could bring us in. Okay. As you all know, today, Mike and I are going to provide an overview of the environmental due diligence process, procedure, and regulatory implications for realtors and lenders here in Rhode Island. We're going to keep it at a pretty high level, and then we are going to try to get our portion of this presentation done within 30 or 40 minutes, and then open it up for comments and questions at the end. Before I start, we took a look at the 60 plus attendees that have joined us today, and we've got a really great group, many of whom I've worked with. Both Mike and I have worked with over the past 3 decades of working here in Rhode Island and New England. And I like to start these presentations off by saying what we talk about here stays here, right? Everybody nodding, yes, right? Because the real value that we've found over the years that come out of these types of presentations is the actual sharing of experiences and war stories. I'm not going to ask people to actually share site names, but we can all come away from today's conversation better informed and hopefully better at our jobs with what we will share with each other. So without further ado, Corey, if you'd go to the next slide. Okay, I'm going to toss this one to Mike. Mike's going to give us a brief overview of who becomes environmentally liable and why. Mike?
Sure. Thanks, Rick. So, as we're all involved in different sides of real estate and financing transactions, it's standard practice these days, especially in every commercial transaction, to have some version of an environmental assessment. And, if a buyer and seller don't agree and there's a lender involved, they'll certainly agree. And even if a buyer is paying cash and they want to be a cowboy about it, they likely want to end up with a property that down the road, if they go to flip it, or they want to let it to a responsible tenant who's going to look at this, that there's no hair on this, that they're not getting challenged on the price or the terms because of the risk. And they want to make the property, they want to make sure the property is financeable to some buyer that they want to flip the property to, or even a tenant if they want to go get a loan for landlord tenant improvements as part of the lease agreement. And so as we do a site assessment, Rick will talk about this later, but they are relatively standardized today, what a phase 1 assessment will look like, and Rick will talk about that. When we move on to a phase 2, which is where you actually do, groundwater or soil testing, we'll say that's independent of hazardous building materials that Rick will also talk about. What do we do with the information? Who is required to report? Who has liability? All of that is of interest to you because you probably find yourself often on commercial transactions caught in sort of a complicated arrangement where you might see an owner say you can't test property in a sale, or they might say you can do it, but then there's a complicated agreement between the buyer and the seller where it says that the potential buyer can't use the information, go public with it, go to the government with it. If they're clever, the seller will even say that you can't provide the data to us. Why is that? So on Rhode Island, when we think of ground down contamination, and we won't talk about leaking tanks because that's regulated slightly differently. But when we talk about ground down contamination from historic operations or filling, what the site remediation regulations provide that owners and operators have liability for remediation. And when and under what circumstance would an owner operator have an obligation to even report that would bring them into the system? So it's when we have a soil or groundwater standard that exceeds, let's take soil for residential, direct exposure criteria. So there are numerical lookup tables for certain listed contaminants. If you exceed those, then the quote unquote responsible party has an obligation to report to the DEM. 15 days, follow up in writing. If there's an imminent hazard, it's immediate. So we use owner operator as a trigger for who's obligated to report. You may have caught on to the fact that a potential buyer is never, a responsible party with an obligation to report. These under the site remediation, under the LUST regulations, leaking underground storage tanks, which is the second bullet below on the right, the reporting obligation is different there. There, it's any party having knowledge of a release of a leaking tank. So is that you? Is it Rick? Is it me? It's any person having knowledge, which is different, right, from a triggering threshold under the site remediation regulations. Emergency response goes back to owner operator under section 6 of the remediation regulations. Rule 5 has to do with reporting obligations in normal circumstances when you exceed a threshold. In 6, you have a reporting obligation from an imminent hazard, and that still only goes to the owner operator. So a buyer and a broker would be free from that. The oil pollution control regulations have yet a different kind of exposure scenario, which is more owner operator. But on the left-hand side, what you hear most often, right, is why Rick put this slide up, is we hear owner operator rather than the words responsible party, which is Rhode Island law. And so under federal law, we've heard of the Superfund. So when you have a site that has contamination, it gets into the federal system for evaluation under the hazard ranking system. If it scores above 28.5, meaning the nature and extent of the contamination is basically threatening a sensitive receptor, think a well for a town, think river, think nearby residents, in such a way that the score is elevated above 28.5, it's put on the list called the National Priorities List, which is the quote unquote Superfund list. And at that point, based upon the score, it will have a priority, and the federal government will either spend money and then chase the responsible parties, we use that term again, or they will issue a 106 order ordering all the responsible parties to remediate it. And there, a responsible party is slightly different, but that is any person who owns or operates, any person who arranged for the contaminants to be transported to the site, or who did in fact transport them, or anybody who generated what was released on site. We don't often see the CERCLA liability come into play for any of you. We have a number of Superfund sites. Very few of them have people selling real estate as a big opportunity from a Superfund site. So you don't see that a lot. I'm involved in one right now where someone is actually selling a piece of a Superfund site in order to put solar on it. We're trying to deal with that. But these are kind of the liability schemes that are behind what you probably often see as a dynamic between a buyer, a seller, and a lender. And you always end up with a circumstance where, how do you navigate that? Everybody thinks, how clean is clean? When are the regulators satisfied? What will be financeable? All of these definitions in these programs go into the negotiation that the environmental lawyers and consultants have with each other on the buyer and seller team. You usually just end up hearing about it and participating in the calls, but this is the kind of the framework that we're using as we talk about that. Rick, you're on mute, Rick. There we go.
Corey? So playing off of Mike's discussion of who becomes liable and when, as Mike mentioned previously, it's an owner or an operator who has the ultimate liability, primarily under the DEM site remediation regs, which is the program that regulates the majority of sites that we see that have environmental issues here in Rhode Island. There are a number of less sites, but SiteRem is really the one that takes on the lion's share of sites that have environmental issues. So you ask yourself the question, well, hey, as a realtor, why do I care about this stuff? Well, specifically to you folks as realtors, is it has the potential to hurt your bottom line. I can't tell you how many times properties have been taken on by a commercial realtor and the seller has chosen to not perform the upfront environmental due diligence to help you, the realtor, bring the property to market. In many instances, frankly, I think they just cheap out and don't want to spend the couple, $2,000, $3,000, $4,000 to perform a phase one environmental assessment that is intended to answer the question, is there a release of oil or hazardous materials on this property or not? Now, the savvy realtors out there like Tom and Steve and others on this call, they know it's beneficial to them if they know that the environmental issues are mollified on the front end, because those aren't going to come up as hurdles as they go through the deal. They're not going to get hung up by a prospective buyer who decides to go out and do his or her own due diligence that ends up killing a deal potentially. So first and foremost for you, it's good business to try to get your environmental matters resolved upfront before going to market. And those things start with a phase one, and we'll talk a little bit about those later on. So it's those instances where there are environmental issues that are discovered during the phase one process, where Mike and I will talk about some of the ways we can work around or through or in conjunction with the regulators as well as the regulations, to hopefully not be a deal killer.
Right. Rick, Rick,
Sure.
I would just point out that, you know, here we talk about the duty to disclose. So, you know, we can talk about that in a few ways. One is we call it a reporting obligation when we talk about what we have to tell the agency and who has to tell them and when. But what you have to deal with every day is your disclosure obligations to the parties in the transaction. And so when and under what circumstances, if you have certain information, are you required to disclose it to a buyer if you represent the seller? Or let's say that there's the sly boots, clever lawyers orchestrate a deal where the buyer will do testing, and the results, if they're unacceptable because they trigger reporting, the deal is they're not going to give it to the owner of the property, so that that person doesn't have a reporting obligation, and the deal just dies. What happens if somebody like me on the buyer side just hands you a copy of it anyway? Now you know there's a reporting obligation, and the lawyers who craft these documents, who aren't clever about it or experienced, what they do is they'll put in an agreement that the buyer, if it's me and I hire Rick on behalf of the buyer and we do an assessment, even if the agreement says thou shalt not give the results to the seller, what's the consequence if we do? Right? And so it often slips by where the lawyers and consultants aren't involved, but you get a principal buyer and a principal seller who have a chat, and it gets dumped on them or you. And once you have it, what is your duty if the seller wants to stick his head in the sand and try to keep marketing it? So we can talk about that under your rules. And then we can also talk about the practical fact that if under Rhode Island law, if you are a seller's in possession of a material fact and they don't disclose it to the potential buyer, does that rise to the level of civil fraud? If there's a lawsuit against the seller at some point, you're going to get named without question. And what's your decision tree as to how you're going to manage it and stand by that when it goes to court? Okay.
Thanks, Mike. So the next two slides, we're going to talk first about what a phase one environmental site assessment is, for those of you who aren't familiar with it. And then Mike is going to talk through just briefly the DEM site remediation regulatory process when a release of oil or hazardous materials is discovered at a property. He'll then talk about remedial agreements, and then he's going to talk about the attorney-client privilege and how we use the attorney-client privilege to, in a sense, get a free peek without putting a buyer or seller in a position where they may have to report something that might get discovered during environmental assessment. But first, just going to go to the next slide. And just for those of you who aren't familiar with a phase one environmental site assessment, in essence, a phase one environmental assessment is a story, right? It's a story that typically does not include any testing of soil or groundwater or subslab soil gas. It's a deep dive into a property's historic use history. And there are two standards in our industry that dictate how we as environmental professionals are to perform phase ones and what they are to consist of as part of our investigations. The ASTM is the primary repository of what the phase one is supposed to consist of. And it was only recently, within the last, I think, 5 to 10 years, that the EPA finally got on board with their own standard, which is you'll hear referred to as all appropriate inquiry, or AAI. If after performing a phase one, we learn that there's a threat of a release of oil or hazardous materials, or we actually see a release So the conclusion in that phase one is, hey, there's a potential issue, environmental issue here, and we would recommend a phase two or limited site investigation to further evaluate whether or not that release has in fact occurred and objectionably impacted the property, be that soil, groundwater, subsidence, soil gas. So again, for those of you who don't know what a phase one is, this is just sort of a brief overview. Generally speaking, they take anywhere from 2 to 4 weeks to perform, depending on property type, size, sophistication, etc. Can run from say $2,000 to $5,000. Your larger sites might go 10 or more. But this is the industry standard. All lenders require them. 99.9% of sophisticated real estate investors, even though they may not be using institutional financing, a bank, they require them. So we've been performing these things now for well over 25 years. And this is the golden standard, if you will, for environmental due diligence.
And Rick, I would just add that, so what will happen is sometimes your clients who are sellers will look at these reports or buyers and think that it is actually sort of the conclusion is somehow open to interpretation, or is not a kind of, there's a lot more latitude for the consultant to draw conclusions. But in this phase one, at the end of it, under the standard, the consultant is required to make a binary recommendation, either thumbs up, there are no recognized environmental conditions, or thumbs down, there are. And those are a definition, those are defined terms. And so in the end, if certain things exist, records, past uses, observations on site, then the consultant is required to make a conclusion in that phase one that there are recognized environmental conditions. The next step is they must recommend a phase two. And so those are the things when I read a site assessment, if there's a recommendation, or if I had one recently where one of the consulting firms said that it was formerly a jewelry plating company, and the conclusion was there's a history where they got rid of like 10 drums of waste. So they concluded that all of the chlorinated risks were addressed. Whereas that's the wrong conclusion under those definitions. You have to conclude, given that use, that you have to go to a phase two, and they did not. And so anyway, it's just important when you read this, you want to read it for, are there recognized environmental conditions phase two or not? And then you need to order the reasons why.
And so playing off of what Mike said, so now we're going to go to the next slide where we've done a phase one, we've done a phase two or an LSI, and we've discovered a release, a reportable release to the department. And Mike can talk a little bit here about the DEM site remediation regulatory process, which is linear, and it's better than other states. I'll leave it at that for now. Mike, you want to talk a little bit about the site rem process?
So in the interest of trying to meet our half-hour challenge, which it's clear we're not going to do, I will just talk about this very quickly. So once we have a phase two that shows, by way of example, you have an exceedance of residential direct exposure criteria for arsenic. I'll pick that because your front yard and backyard, if you live in virgin land, probably exceeds that standard because it's naturally occurring in excess of the standard. So let's just say you have a reporting obligation. The owner operator, we'll call it the responsible party. Then what happens is DEM says, thank you. You file a release notification form. They say, thank you. And then the SAGE would submit a work plan showing what they plan to investigate based upon the information, where they're sampling, what they're sampling for. Then after DEM would agree, then SAGE does the work and submits a site investigation report that would summarize the findings, recommendations, and propose remedial alternatives. DEM would select a remedial alternative in the program letter, put that out to comment. And then what would happen is, assuming that the choice is ratified or not going to be modified by DEM, you get a remedial decision letter. And then what happens is SAGE gets a work plan approved to implement that. So it's not enough to say you're going to deal with vapor intrusion. The question is, you got to design a system to do it. And so that would all be in that. You can say you're going to cap it, but then you have to design the cap. All that's in the remedial action work plan. Then once that's submitted, you get a remedial approval letter. And then SAGE goes out, does the work. There's a completion report, sort of an after action report. And then what you get is one of two documents, which are the documents that make deals usually financeable, right? The first is a letter of compliance. You've completed all of the work and the site's closed. And that's a recordable document that goes in the title, forever and none. It's compliant at that time, but only with respect to what's been disclosed. There's always a reservation in those that says if there's any new information we don't have or anything new that happens, that's not, this isn't a get out of jail free card for all of that. Then there's something that you may run into, which is called an interim letter of compliance. So suppose the remedial action work plan involves digging up some oil contaminated soil or other contaminated soil and removing it. And there's been some groundwater impacts. Even if you're not going to do active treatment of the groundwater, you may ring the property down gradient with sentinel wells that you're testing, and you're just trying to demonstrate that the contaminants are decreasing in the groundwater passing through that point, and that the remediation, in this instance, source removal, was effective. And in that instance, let's say you had to do 8 quarters of groundwater monitoring before DEM would make that conclusion. You would, as soon as you are done with the source removal, you would get an interim letter of compliance saying everything but the groundwater monitoring has been completed. And so that's kind of an interim step, thus the word interim. Oh, and what's important for you to understand is when you get a deal and everybody's under contract and there's a due diligence period and somebody ends up reporting, these stages that you go through are absolutely not controlled by regulatory timelines. So this is one of the times where hiring people who you choose gets you in and out of this place in 90 days or gets you 30 days or gets you in and out in 4 years, because there is no requirement. The DEM decides whoever the project manager is, and there may be, and if there are supervisors involved, all that's, they have so many things on their desk. What are they doing today? And there is no 30 days of this, aside from the 2-week public notice, there is no structure to the timing. And that's why you'll see some projects go very quickly and some not so quickly.
Let's go to the next slide, Corey. So Mike, why don't you share with the gang about remedial agreements and how they work in the whole DM process?
Sure. So we probably all heard the term brownfields, right? That was an EPA coined phrase where a brownfield is a contaminated, typically urban site. And because of the remedial costs, what had been happening was developers would say, I could buy this building in downtown Providence and do remediation, or I could go to a nice verdant field in the middle of South County, take a farm or some other thing and build my building there. Those are green fields. In order to stop that and not have all these inner city buildings becoming abandoned, right? What would happen is the EPA allowed credits and allowed agreements to developers to try to put those back into play. And there were funds available for them. In Rhode Island, when we hear the word brownfields agreement, we have a statute called the Industrial Property Remediation and Reuse Act. And pursuant to that act, the DEM is empowered to enter into what used to be called settlement agreements. They're now called remedial agreements, and they're slightly different. But the idea is, if we know a site's contaminated, your buyer can, once they have a purchase and sale agreement signed, can submit an application, and Rick would usually do that, for your buyer that requests certification that they are a bona fide prospective purchaser for good faith. Meaning we have an interest in buying the property, we didn't contaminate it, we're not an owner operator, and we would like to be eligible post-closing for a remedial agreement. Typically, it's a couple of weeks and they say, fine, you have the certificate. Now you can close on the property, assuming you've costed the remediation with Rick and you know what you're doing. You buy it and you do the remediation. At the end of the remediation, you will have, well, in the process, you'll have signed this agreement. When you're done with the remediation and you have an interim letter or a letter of compliance, by operation of the agreement, the state of Rhode Island is covenanting not to sue you again or ever for that identified contamination. They are also agreeing in contract that you are being granted contribution protection, which is a legal bar from your abutters or anyone else suing you for the same contamination. So this, as you might imagine, has a little more finality to it and protections than a simple letter of compliance, which you would also have. And so where you have deals that we're going to manage the environmental issues on in a complicated way or a very simple way, these are easy steps to get you something that is of real value in the marketplace and in getting financing. Your clients who are buyers of commercial properties who are sophisticated, they all have their favorite lenders, right, that they go to. But eventually, if they're successful, these smaller institutions, perhaps they can only hold so many of their loans. And so they have to participate them, or maybe they want to shop terms and get better rates in terms somewhere else. This really is a golden ticket to allow your developer clients and buyers to actually take the hair off a project that they already intended to spend the same money anyway. So it's a valuable thing to do. And again, there is no timing element to this other than a couple of weeks public notice associated with the, if you're going to leave contamination there, the remediation process. And so this is a valuable tool to use for your clients.
Mike, the remedial agreement, right? They have to complete the site investigation report and the remedial action work plan, right?
What they have to do, so Rick's talking about drilling down who's eligible. You have to have clean hands, but then also you have to be the recipient of a remedial decision letter, which is the approval of that remedy. So if the buyer has already costed the remedy and they've received the remedial decision letter, you have to get one as a buyer. All that is a phone call, work with them, and they will reissue one to you, to your buyer. But that's a procedural step we have to do. And again, that usually takes no time.
And typically, right, in these instances, lenders will look for the remedial agreement and then more substantively with an approved remedial action work plan that's been costed. That can then get structured into the deal so that it can then transact.
Right. So that doesn't really relate. Yeah, it doesn't. It's not exactly the remedial agreement. You're right, Rick, but it does as you try to cost. Once buyer and seller have a handle on cost of remediation, usually we can support that with legal opinions and consulting opinions that get lenders comfortable with closing the transaction as long as the buyer has the wherewithal. You put money in escrow, you do whatever. Some of the banks, and we won't name them, but one in particular, it's almost always they want you to escrow 3 times the cost that you've estimated. Or what they want you to do is they'll lend you the money, but they'll hold back that amount of money 3 times the cost, and you're paying interest on it that whole time till you complete it, and then they release the funds. So in the late 80s and into the 90s, Rick and I had worked variously on a lot of the lending institutions in the state and throughout New England, writing their environmental policies and training their loan officers. And so as they all hire in-house compliance people. And so what ends up happening is, although the mechanisms to evaluate property have been standardized with those ASTM standards, and the conclusions consultants must have are there, and we have much greater certainty as to what standards we're trying to achieve in remediation, and costing is now a mature industry, you still have lenders who really are not competitive in the market based upon one person's assessment of risk and appetite for risk in underwriting. So we can often tell you right up front on a deal your client's doing, you're not going to get financing from Sovereign on that. That's not happening. You can go, here are the places you can go. We just did an identical deal at this bank or that bank. And so, you know, we can help in that way. But those are things you also probably have a lot of experience with.
Right. SBA is difficult. Like our experience with SBA backed loans is they're very reluctant in our experience to want to loan on a project that has yet to be remediated. But they seem to be coming along these last couple of years where they're willing to start looking at some deals that have yet to be remediated.
All right, Rick, I know we're getting dangerously close to the witching hour, so we'll have to speed through these.
Let's go to the next slide. This is my favorite. Mike, talk about attorney-client privilege.
Okay.
Can we hear Sergeant Schultz? No, I'm not hearing him. So those of you of a certain age remember Hogan's Heroes, and you remember what Sergeant Schultz used to say. And that's sort of the heart of what the attorney-client privilege provides, or for both buyer and seller. And Mike, why don't you tell a little bit about that?
Sure. So, you know, we all have an idea, right, of what attorney-client privilege is, which is a communication between an attorney and a client relating to the legal advice that's being offered by the attorney. In that instance, I cannot be compelled to disclose that. And it's not evidence, nor can you be required to say what I told you or what you told me in that regard. So how does this impact chiefly reporting obligations? So the way it works typically is someone will go to a consultant to say, okay, we have a deal, we're doing due diligence. And we're the buyer, we want to go do assessment work, or the seller, we want to do assessment work. And so if they engage Rick directly, as soon as Rick gives them the environmental testing data with the statement that, yes, it's above residential direct exposure criteria, you now have to report, they are now obligated under the law, right? They're a responsible party and they have to go to the government with that. So is there an ethical way using the attorney-client privilege to insulate clients from that? And the answer is yes. And the way that works is I am typically engaged by the client, and I would then have an agreement with SAGE. It would say that they are being hired by me to assist me in rendering legal advice to my clients. And we typically have the payments, you know, understood by the client, and they're going to be billed directly, but that's the representation. Now, SAGE would then do the work, and before going hard with the data, we would talk about it. And I'd already have an understanding from the client as to what kind of appetite they have for spending money on or building it into a deal. And so this can go as far as you want. Rick could even tell the lab, I don't want you, when you have lab results, to actually print lab certs without calling me first. And then Rick would have verbal lab data. We would talk about it, and we could decide what we wanted to do with it. And then if you were my client, I would simply tell you that my legal advice is that you not proceed with this transaction as structured. You would never have data. The client would never have data. And I would never have data. And Rick wouldn't have lab certs. So in that instance, that is a way that the attorney-client privilege can be used to protect our clients from risks that they can't really appreciate. And lest you think this is challenging ethically, you know, this has been addressed in every context. So for instance, if any one of you gets audited by the IRS, you're going to have a lawyer defending you. They're going to hire an accountant to forensically look at what your accountant did. And if the information developed by that expert accountant hired by your tax attorney who's defending you, if what they communicated to each other or you were discoverable you could see how you wouldn't be able to mount a defense. And that's how the case law has all gone. And so that's the basis under which this happens. I would caution you that only advice is protected. So if I'm your attorney and I go to your plant, I go to your office and I see the dead body, and I give you advice as to whether you should run or call the police, my legal advice is privileged. If I were deposed, did you see the body? That is not privileged because that's a fact. So in theory, when you're looking to properly and ethically use the attorney-client privilege, you have to almost manage the dissemination of facts because those are not privileged. So anyway, this is coming up all the time. I in our firm, in other firms, you see this all the time where buyers and sellers lawyers are hiring the consultants, and that's the reason.
Right. I've over the last 5 to 10 years, we have seen our primarily our phase 2 work shift from being ordered directly by clients or their lenders to probably well in excess of 75% of that work now being we're being engaged through legal counsel for just this reason. Corey, that's next slide. Question comes up all the time. Hey, can I just leave this stuff on site? And the answer is yes. As environmental regs and our understanding of the exposure to environmental contaminants has matured over the years, our regulations have reflected that knowledge. And in many instances, and actually the largest or the greatest percentage of sites that do get reported to DEM and other state environmental agencies, you're allowed to leave contamination on site beneath caps, such as pavement or buildings, and that contamination needs to be contained within the 4 corners of the site. It's not migrating off-site and impacting third-party properties. And there's typically an ELUR or an AUL recorded against the deed on that property, saying that it is allowable to manage this contamination on site beneath these caps. So a lot of folks in the past have thought, oh, my property's contaminated and it's worthless. That's not the case. The regs have matured to enable us to do this.
And Rick, just to address why that is. So it used to be that the regulations were, and this is in the 80s, that the regulations were absolute. It didn't consider that property would be used for industrial purposes as opposed to an organic farm or for residential purposes. And so every property had to be cleaned up so that you could live on the soil, drink the groundwater, farm the land, all of that, which made no sense given that you could put a deed restriction saying you'll never do those things. And what we developed is all of our soil and groundwater standards are risk-based. So we have standards that, assuming you're exposed, right, below the standards, that you do not have risk, it's not a carcinogenic, teratogenic, or mutagenic risk that is greater than 1 × 10⁻⁶ or 1 in a million. And so what we do is if it's above those numbers and you eliminate the exposure pathway by putting pavement on it, then you've eliminated the risk there. And so that's how that's evolved. And but you will still see, I won't ask Rick to take a bow on this one, but we just put under agreement a piece of property where the seller agreed that the remediation was, call it $5 million. We discounted the price. We're doing it for $700, leaving it on site and managing it. And it was a publicly traded company on the other side. So you can do that end to effect. This is an imperfect market for your buyers and sellers.
Thanks, Mike. Next slide, Corey. I'm not going to dwell on this one too much, but these are 3 examples of sort of your basic site where contamination is discovered in soil and maybe a little bit in groundwater, but it's contained on site. The majority of sites that we encounter here in New England sort of fit this profile. Yeah, you've got some contamination, but it can be managed on site. That's our site number one here to the left. The example site here, number 2, is a property where we've got a little bit of soil contamination, no groundwater contamination, but we've got what's known as subslab soil gas contamination finding its way into a building. This is an old dry cleaning facility. And vapor intrusion has become a much bigger issue over the last 5 to 6 years as the regulators and the toxicologists have learned that subslab soil gas vapor intrusion is a real health threat to folks. So that's an example of a typical subslab soil gas vapor intrusion site. And last but not least is site number 3, which touches all the bases. As Mike pointed out earlier in the conversation, this is a former NPL site release, upgrading off-site source, bleeding under multiple properties, getting into the subslab soil gas beneath this mill building, and ultimately discharging to the river. This is about as bad as it gets. They're still out there, these types of sites. You think by now, after 30 years of looking at properties, we would have all these in hand, but this is one that recently rose to the surface, if you will. So anyway,
and Rick, I'd like to just comment that as you look at the worst case scenario on the right, if I asked you which one ended up closing, the one on the right, we're closing. We're buying that property,
right.
And to the advantage of seller and buyer. And we did it in exactly the way we've talked about in the prior slides. And so it doesn't have to be clean to close.
Right.
You just have to understand it, quantify it, build it in, and have a path forward that gets you to the point where the down gradient receptor we can get you home to have a financeable property. And that's what we're doing.
Great. So next slide, Cor. So, Mike and I have been talking all along about ground down environmental issues, soil, groundwater, subslab soil gas. Well, if you're familiar with home inspections, you're concerned about the building and the infrastructure that supports the building. Well, what we've seen over the past few years as savvy lenders and developers and investors are rightly saying, okay, I've done my environmental due diligence on the ground down stuff. What about the ground up and the in-building stuff? So we're doing more and more phase 1s and property condition assessments concurrently for transactional purposes. For those of you who are not familiar with a PCA, again, it's another ASTM standard. And it not only looks at your classic hazardous building materials issues, asbestos, lead, mold, PCBs, that type of stuff, but it's also looking at the building systems. And if we can go to the next slide, Corey, I'm just want you folks to look at, this is a spreadsheet that a PCA includes, where it costs out over the course of 12 years, each of those property systems, ranging from a foundation to a roof to ADA compliance to plumbing, HVAC. And we've got folks that specialize in costing those building systems that goes into a PCA report for lending purposes. The next slide is in addition to that. Again, you can kind of see what those issues that are touched on by the PCA.
Mm-hmm.
Again, that's sort of an emerging trend. Mike and I have been tackling these types of things on transfers as well. Mike, did you want to add anything on that?
Yeah, just that there are results that you would never anticipate. So there was a large bank building being sold downtown Providence for a lot of money. And then it was discovered that all the windows had to be replaced because it was an old mill building. And, there's a number for that, but it turns out that all the mastic in the windows had PCBs in them. And I think that was millions to get rid of those.
That's right. You're exactly right. It was millions.
This is all public information, but Rick and I worked on, a project in East Providence where you had a demo cost. Well, as soon as you started to do the demo, you realize that the concrete block that was used for the walls, someone had sprayed fibrous asbestos in the holes as a protective measure. So now you got to decon the whole thing and, exponential expense. We often see that, that we all know about lead and asbestos, but there are any number of evolving hazardous building materials that if we want to do justice and proper due diligence for our buyers, we need to at least offer them the opportunity to assess all of that to make sure they're not buying a liability.
Great. Next slide, Cor. We've heard, Mike and I have heard people in the past complain about DEM. And anytime somebody complains about DEM, I immediately ask them, I say, well, compared to what? Compared to what states? And, we've, Sage and Mike and his team, we've worked up and down the East Coast. And I got to tell you guys that DEM's regulatory programs are pretty darn good compared to other states. It's one of the few states left that doesn't have a privatized program where Mike and I can get on the phone and talk directly to the decision makers within the department and move projects along much quicker and oftentimes less expensively, if that's a word, than we would in other states, such as Massachusetts or Connecticut. So when you hear people bitch about DEM, think twice. Our day-to-day experiences, those folks are doing their best with what they've got, and they've got a regulatory structure that really is conducive to moving contaminated sites through the system fairly quickly and reasonably. Now, that being said, DEM, like other institutions and other businesses, they're experiencing the same kinds of things we're experiencing in our businesses, right? A lot of folks are retiring, so they're losing a lot of that institutional knowledge that has accumulated over the last 30 years, and they're bringing in new staff that doesn't have that experience. And 10 years ago, DEM had a staff of over 600. They're now less than 300. So they're doing a lot more with a lot less. So I wanted to just make it clear that DEM, we've got it pretty good here in Rhode Island relative to other regulatory programs. I don't know if you want to add to that, Mike.
Yeah, I was just going to say that, in Connecticut, so Rick and I had a common experience working for a railroad that, the former Providence and Worcester, right? Now it's Genovese in Wyoming. They had property in New London, Connecticut that came with the acquisition. We looked at that property. It had some contamination. We then looked at property for one of the developers at Kettle Point here, which was a former oil terminal that we developed. They had contamination. In Connecticut, it's odd because you can have contaminants with the same risk to people, but if they didn't come right from a certain facility, like a specific source, then they're not regulated. And so they have a voluntary program. So Rick and I end up telling the clients often, you have to kind of go into this voluntary program if you want a seal of approval so you can take it to banks. And they're like, well, if we're not required to, and you have to explain that the business world and the financing world won't allow you to do it because the regulatory program isn't robust. And then in Massachusetts, I have a matter right now where in Massachusetts, your LSPs can just, for certain projects, can just take them and close them out all on their own without review. Well, think of what really happens. Some owner of property who's thrifty gets 5 different people to tell them what it would cost, and they hire the cheapest one, which means maybe you're not getting the best advice as to what is necessary to close out the site, and you're subject to audit. I have a property right now where they thought it was closed because they did just that. They ended up with a guy in a truck who was his consulting firm, and he was $5,000. The next closest bid was $48,000. And, you know, a few years later, all of a sudden it's audited. You found you have a groundwater plume impacting the whole neighborhood, and you're right back at it. And you have your great lawsuit against that consultant, which has, as the contract you sign says, that it's their limit of liability is the lesser of what you paid them, or whatever the policy limit is, like $50,000 or something for professional liability. So that's not worth going after that guy's assets, and that's where you are. So Rhode Island is pretty good. We have, everybody has good access. I think that the DEM really is trying to promote business and put properties back on the market. They are providing grant monies. And I really think that this is probably one of the easier states to do business on the East Coast in that way.
I agree. I agree. Thanks for that, Mike. So the next slide is kind of funny. I'll let you take it in, give you a minute to read it, and then we're going to move on.
My legal advice is not to read it.
All right. With that, Mike and I want to thank everybody for your time, and we want to open it up. Corey, if you go to the next slide, and then the next after that. And we're happy to answer any and all questions you folks might have.
Thanks, Mike and Rick. We do have a couple of questions. The first question is, how likely are potential purchasers of a brownfield site involving remedial agreement at risk of finding additional contaminants not protected by the agreements after making the deal, and potentially bankrupting the project because the new contaminant wasn't involved in the protection agreement? It's a long question, but hopefully you understand.
Yeah. So if we're talking about the remedial, like what your protections are, so it's your absolution as granted is only as good as the level of your confession. So you would have had the only protections you have relate to the information that's been disclosed to DEM. So what we have these days is it depends on how long ago was the study done, you know, because may have been commercial activities in the intervening 11 years. Then you have, did they test for all contaminants of concern then? Did they leave out PCBs? Did they leave out contaminants which are now regulated? Did they decide that they were going to do a grid that was 60 feet and they got the DEM to agree to it, but you're only interpolating data between those points? So would a 30-foot grid have actually produced the data that shows that you have contamination? There's a site in Warwick that, again, Rick and I have worked on, that we had a whole $15 million was spent remediating it. And you had a whole system for intercepting, evaluating groundwater leaving the site. And there was a 30-foot or even less window. What was that going across Strawberry Field Road, Rick? How was it? Yeah. So for years we thought we understood it, but you can't test everywhere. And your clients don't usually want you to put a well every 4 feet. So there are gaps in data, and it really depends on how robust the assessment was. So typically, if you're buying a deal like that, we want our consultants to look at it and tell us, as if it's brand new, what would you do? What do we do to protect ourselves here? And some of it, unfortunately, is going to the exact same sampling points they did, but you're sampling for a larger suite of samples, right, of constituents. So that's how I look at it. Rick?
Yep. Yeah, same thing. If you've got a site that has an old ILOC or an LOC, or was closed with a no further action years ago, say greater than 5 years ago, even greater than 3 years ago, you want to look at it with a fresh set of eyes, because new contaminants, or we refer to them as emerging contaminants of concern, are being added to the contaminant list that is being regulated. So you'd want to know, hey, is there a possibility that one of these new contaminants might be on site that wasn't looked for previously? And then what we're also seeing is, as I mentioned previously, subslab soil gas vapor intrusion into buildings. The whole vapor intrusion issue in Rhode Island has really only come about within the last 2 to 3 years. And it's been added into the ASTM phase 1 standard. So if a site was closed that might have had contamination beneath the building, but no one ever evaluated for indoor air issues as a result of that, those are the kinds of things that you need to look at with a fresh set of eyes.
Mhm.
What else, Tom?
So I guess, Tom,
Okay.
the short answer is, even if there's a letter of compliance and a remedial agreement, a prudent buyer or lender or tenant would look at it with fresh eyes. And oh, by the way, Tom, I don't think I mentioned it, but when we talked about remedial agreements, we always talk about it in terms of buyers. Tenants are also eligible. So if you have a client that wants to go into a facility as a tenant that you know has contamination and they're worried about it, about being tagged an operator, we can get you a brownfields agreement for your tenancy as well.
It's good to know. The next question I have, probably more to you, Mike. How do you advise taking title to real estate with potential environmental problems to avoid potential liabilities?
Okay, so what seems to happen these days is it's less, very few of our clients actually want to own anything personally. So they almost always create limited liability corporations now that we have them in Rhode Island. A limited liability corporation can operate in different ways for tax purposes, but effectively what it does is it limits your liability. It's a corporate shield. So that's commonly what I see. What I would advise against is you don't want your operating company, you don't ever want to own it personally, right? Because then everything you own is in peril. But if you have your operating company acquire the real estate, so it's just an asset of the company. Now, if there's a large environmental problem, all of the assets of the business are exposed. I'd rather strand those in the LLC, which is probably what you're seeing 99% of the time. There are, what you sometimes see is in old timers is they'll either own it personally, or even if they have it in LLC, when they do their estate planning, here's another opportunity to fumble this. So what do? Is the family trust or the will, are you leaving the stock in the LLC, or do they transfer the property itself, a deed, right into the trust, which then puts all the other trust assets at risk? I see that more commonly because we often see estate planning attorneys live in silos. A lot of them are sole practitioners or smaller practices. We have our large estate planning practice keeps me busy because we actually have environmental capability with some depth in-house. So it comes up all the time because we're internally watching for that. But I'm not sure that would necessarily occur to estate planning attorneys in the same way it would to transactional attorneys or real estate brokers, for that matter. So I think the LLC is the obvious answer. Partnerships are available, but a vehicle that will protect you. If you're the general partner in a partnership, query how that works for you in terms of liability. But I think the LLC is typically the vehicle of choice that we see and recommend.
Okay. This is kind of an off-kilter question, so I'm going to give it to Rick. How would you handle a property that had was formerly a camp with a number of outhouses on it? Are there issues that a potential buyer should have to address with this situation? Or, what would you do?
So one of the questions that I would have was, does the property have its own private water supply? Or is it connected to a public water supply system? If those are still active outhouses, we'll call them cesspools, right? Rhode Island has a new rule where you're supposed to properly decommission cesspools. So that could be a potential liability that you'd want to look at and make sure you decommission those things properly. From a health and safety standpoint, if that stuff's underground, you don't have any plans to dig into it, and you're not drinking private water from on site, that would be how I would manage it.
Okay.
Tom, I'd throw a couple other things out there, and Rick, I'd like your thoughts on this. So when you say a camp, and the first thing that comes to mind is, was it ever used as a farm? And the problem with farms, even apple orchards and all that, is that for all of our past, the pesticides that were used were all heavy metals based to poison the critters, right? And so you'll often have arsenic, way in excess of residential standards. And so you may have acreage covered in arsenic that would have to be addressed to the extent that the property is no longer used for farming. In addition, if what you have is a well that you put in 1923 that's been serving this camp forever, you may be now regulated as a public water supply system and you don't know it. And now you got to get a license. You have to have a wellhead protection area of 200 feet. You can't do anything within the 200 feet. You have the reporting obligations. You have to have a licensed, public water supply system operator run it. There's quarterly reporting and testing. Like, you may have all of that if you continue to want to do that activity. Then you'll look at whether or not you may have outhouses for the camp, but was there any main building, a lodge? Did that have a big septic system? What ended up down the drains that go to the septic system? Were there garages that had floor drains that went to cesspools, which you often see at these things? So I think there are a lot of things I would ask more than the outhouses. If what you have is a camp in the middle of nowhere that's never been used for anything and has 3 outhouses and no other structures and no water supply system, I think you're probably not that concerned about that, but you do have to decommission the cesspools.
Okay. 2 questions, primarily geared towards our appraisal members, which I have to talk about an upcoming event at the end of this. But the first question is are there databases or other information that would help appraisers come up with values on contaminated properties? Is there a list of we can go to and find contaminated properties that have sold so we can use them in an analysis of another contaminated property?
You know what, Mike, I'm not aware of a list like that, but and Tom, you and I have done this on occasion in the past. Oftentimes we'll get a call from a broker, a realtor, who'll say, "Hey, Rick, I'm considering taking this assignment for this property. It looks old, it looks nasty. What can you tell me about it?" Now, if we haven't already done a site assessment on that property, we have access to paid databases. We call them environmental database searches. Very creative, right? Costs about $300. They're geo-referenced, so we type in the address of that property and it tells us whether or not that property or any of those in the immediate surrounding area have been identified on an EPA or a DEM database where there's been a release or there's been a tank or something like that. So if you want to get a quick idea about whether or not there's any intel on a property, that's a fairly quick and cost-effective way to do that. As for a database that would help understand how contaminated properties have been valued and sold, I'm not familiar with anything like that.
Yeah, I think the question is more along the facts is if I have a contaminated property, is there another place I can go and do some research to find other contaminated properties that have sold, just to do the research beyond that. But again, I think that's how there's a way to find them. You'd have to go to more research to see if they've sold and things like that.
Interesting question, but I get it.
The second one I have is if brokers become experts in environmental issues, do you see opportunities out there for them in this market and other markets, to leverage that knowledge.
Yes. Yes.
Yeah.
Yeah.
It's although you don't see it and you think you have the great relationship with your client, you don't know how many times we get consulted on what broker they should use if they're going to bring it to market.
Yep.
And there are brokers who simply don't want to learn the vocabulary or delve into this and kind of leave it to the lawyers. And if the buyers and sellers have sophisticated environmental counsel and consultants, that's appropriate. But I imagine many of your deals are more real estate people doing real estate deals. A lot of them are cowboys, they're entrepreneurs, they have appetite for risk, and their lawyers might be real estate lawyers. And so what happens is, to the extent that a broker has educated themselves, and it's not, you don't have to be able to do the testing or even compare the sample results to tables. You just have to kind of be able to know what we've talked about in the slides, which is not that hard to know that there's a process and it works and that you should go engage the people to do it. That's kind of what you have to know. But if you're not educated, you don't know the possibilities. You see deals are dead when they're not. You see deals are alive when they're not. And so I think an educated broker is a really valuable member of the transaction, because you're kind of the glue that keeps the transaction together. You talk to the other broker in a way that the lawyers can't, and the way the business people sometimes don't. And so I do find that it's important to me in a transaction to know who the other lawyers are on the other side, who the consultants are on the other side, and who the broker is, because it really impacts the ability to get a commercially reasonable deal done between willing buyers and sellers.
I'll give a fairly recent example as well. And this happens pretty regularly. I mean, Tom's asked me this in the past, Steve Kirby as well, and others. They'll call me and say, "Hey, Rick, I'm being asked to take this property on, but it's big. It was, let's say it was a former whatever, jeweler, tank farm, whatever." He said, I got to believe there are file cabinets full of documents at DEM on this thing. And they'll appropriately ask me, say, "Would you mind looking at that file and then synthesizing it into a layman's document that I can have available to me when I go to market, or for me to understand what has been the environmental history on this property? Where does it currently sit in the DEM's regulatory process? And what might those hurdles be when we start talking to prospective buyers?" And, I appreciate that, right? Because it's an opportunity for me. It's an opportunity, but I typically have to invest 10, 20, 30, 40 hours of my time, of my staff's time, in digesting all of that documentation and then putting it into an easily digestible, call it a Reader's Digest version, that the realtor then includes in his or her marketing package. And when it comes time for the tire kickers to go beyond tire kicking, and they actually want to walk a site and start talking about what those environmental issues and limitations may be, who gets the call? The guy that's invested his or her time into developing that type of a marketing document. So yeah, they're rare, right? A few of them are on this chat today, but I find that realtors that take an interest in the environmental story that goes behind the property that they're going to take on, it makes them more effective, and frankly, I think they get more deals in the long run, because once it's known that a particular realtor handled a big complex real estate sale and transaction, their name's out there.
Okay, we're getting close to the end. We don't have any more questions in the chat. What we would like to do is if we can open up, Jack, if you can open up the mute buttons, and if anyone does have a question, please don't, speak up. We'll try and see if we can answer it in as quick as we can, because we are coming up on 6 o'clock. So Jack, if you can do that, and if anyone does have a question, please feel free to state your name and ask the question. Boy, you guys are thorough.
Paul's raising his hand.
If you have a property that was never developed or was, clearly developed in terms of its use was always easily defined, and there is an issue and it has migrated to your property, what is the next step?
So has the property, is the upgradient offsite property that's contaminating the subject property, is that currently in the DEM system?
Yes. In this particular case, actually, it is an upgrade, but there's a very small street called River Lane. And it's because back in colonial times, there was a little river that went down there. And at the bottom of it is a dry cleaner. And you can see the little monitoring wells in River Lane as it goes up. But it does, there was a dry cleaner there for the last 60, 70 years.
Right. So DEM has taken the position that it's the responsibility of the property that's being impacted by the offsite property, that they have a responsibility to interdict that plume. So even though they didn't cause it, this is where it gets to liability, right? Present property owner owns the problem, regardless of fault. And so that's why, yeah, if DM doesn't have somebody to go after that upgradient contamination source, then yeah, the downgradient property that's being impacted will be looked at by DM, right, Mike?
Right. So Paul, let me, so Rick's giving you the consultant practical approach. So the legal issue is framed this way. If you are the downgradient receptor of contamination, you are eligible to apply to DEM for a downgradient receptor letter. And what it'll say is, so long as you allow the upgradient responsible party to enter onto your property and perform whatever remedy they need to do, then they will not look at you as a responsible party to remediate this. So that's the policy. What Rick is talking about is we have a mill building that's been impacted by an upgradient dry cleaner. Any set of facts were the downgradient receptor. There's no doubt. Via less than elaborate reasoning in an email, DEM has said, yeah, that's all true, but we're not giving you a downgradient receptor letter unless your upgradient property owner is viable. Now, all the times that they've issued downgradient receptors letters, they've never seen the finances of the upgradient responsible parties. So we just ran into this. And then they said we don't have to remediate it. We have to control on-site risk like vapor intrusion. We don't have to remediate it unless it's leaving our property and hitting the river. And none of this makes logical sense, right? Either you aren't responsible as the recipient of the plume from above, or you are. It can't be. It has to do with how much money the upgrading. So we will litigate that or revise the policy or take it to task. We've worked it out, but it's a good question. And in the first instance, I would have the consultant apply for a downgradient receptor letter. And if you get that, now you're bankable and you can let it be. That's what I would do. If you're unsuccessful there because of these crazy other theories, that's when we get our hammer and our tong and we go at it on that one with the agency, because there is no legal standard that gets you to the result Rick described, even though we're in that circumstance right now.
Thank you.
Hi, I have a question.
Oh, sorry.
Go ahead.
It's Patty Flowers from IPX, and we're a 1031 exchange intermediary. And so when we structure reverse exchanges and build to suit or improvement exchanges, we have an entity that takes title to the property. So in order for us to go ahead with that, we always require the client have an environmental phase one, at least, for us to review first. And then obviously, if we find something that's uncomfortable to our company or our parent, we have to go further in depth. So I was wondering if we needed to use your services, what do you think is usually about the running time now to get a phase one accomplished? Sometimes we don't even get a call that someone needs to structure a reverse exchange until a few weeks before closing. So I feel like a phase one might not take too long, but ordering it and having time for you to do it the lead time might be longer.
2 to 4 weeks typically on a phase one, depending on property size, type, location. If need be, we can get an executive summary usually within 5 to 7 business days. It may not include all of the phase one elements, but enough to give you a sort of thumbs up, thumbs down.
Yeah, get a feel. Great. That's good to know. Thank you. Because a lot of times we need to be able to refer out to somebody. So that's great.
Happy to help.
Any other questions?
If I could, this is Jen Gaffney. Hey, Rick. Hi, Mike.
Hey,
This
Jen.
has been excellent, by the way. Actually, circling back to Paul's question, I actually had a follow-up, selfishly super specific, something that like I literally have on my desk right now. But that down gradient property status or comfort letter, is that follow the property owner or the property? Is that assignable to a new buyer, for example, or does that stay with the property?
Property.
Excellent. That
Yeah.
was exactly what I was hoping you'd say.
The magic is getting that without
Yeah.
having the troubling legal analysis that derails it that we've described. But that doesn't often happen. And it really, I hate to say this, is project manager specific.
Right.
So we try to control who reviews what we give them, because oftentimes where we tell Rick to hand the reporting obligation is where it sits, and that's who does it. So if you have that circumstance, you probably don't want the report to go to the project manager we're having this issue with. We probably want to manage that differently.
Understood. Thank
If
you.
I've given that in the most subtle way possible.
Very good. Thank you.
Welcome.
Anyone else? Okay. Well, I want to thank Mike and Rick for this presentation. It's been one of our better ones. I will tell you that it's my experience in listing most of the properties we deal with at Sweeney Real Estate and Appraisal to suggest to our ownership that they reach out to Rick, at least on an initial standard, to try and determine what, if any, issues potentially are there. As he has said, it gives you a lot more control of the situation than waiting till you're further along in negotiations. It's better to, in our opinion, to know what's going on going in than figuring it out later. Again, thanks to both of you. It's been great. I will tell everyone that I was remiss at the beginning. I should have mentioned on April 14th will be our next virtual Zoom meeting. At that point, we will be catering more to the appraisal side of the Rhode Island Commercial and Appraisal Board of Realtors with a overview of the appraisal market, moderated by Richard Walensky, featuring Susan Kelly talking about residential side of the business and Zach Durkin talking about the commercial side. Information on that will be going out soon. Rick and Mike's contact information has been up throughout this. If you need it, feel free to reach out to Jack Hudson at RICABOR. We can get you that information. If you have any questions, I'm sure they'll be more than happy to answer them if you reach out to them. And with that being said, again, thank you guys. Thank you everybody for attending tonight.
Thank you, Tom.
again, thank you very much. And everybody have a
Thank you,
good, oh,
everyone.
wait a minute. 2 questions. Something's in the chat. I have to look. Okay. Nope, they're just everybody saying thank you. So thank you all very much.
All right.
Thanks,
Have a
Tommy.
good night. We'll see you at the next one. Thanks,
All
Mike
right.
and Rick.
Stay safe
again.
and sane, everyone.
guys.
All right.
Thanks, Mike.
Bye.
Bye.